Hello, everybody, and welcome to an introduction to the criminal law. Now, this is going to be the first in a long series of lessons covering criminal law from the perspective of the jurisdiction of England and Wales, and we're going to be doing so over the course of the next few weeks and months. This lesson specifically, though, is going to take an introduction to the subject of the criminal law. We'll also be introducing some of the more theoretical approaches to crime, criminalization, and criminal theory. This is going to serve as the first major section on our studies, but I'll get to that in a minute when we look at the final slide. Sorry. And we're also just going to be talking a little bit more generally about the nature of crime, the nature of the criminal law, what the purpose of the criminal law is, and some of the ways in which the criminal law has been interpreted through both the eyes of legal theorists, legal scholars, but also through philosophers, sociologists, criminologists, etc., etc., etc. So this is the first of a series of lessons on a new updated series on the criminal law. We are updating all the way to 2023, so we're going to be covering new cases and new crimes that have, or at least new cases that have come out in recent years. And this lesson, as I've said, is going to be taking a major introduction to the subject. Bearing in mind, however, that the first 5 or 6 of these lessons are probably going to be quite introductory in terms of their content and in terms of the approaches that we are going to be looking at. This is because it's important, and one of the things that I want to instill in this new series of lessons on the criminal law is these new theoretical and critical approaches to the idea of the criminal law. Looking at the criminal law not just from a descriptive perspective, but also looking at some of the normative implications. This is something that we look at if you go to our introductory lesson to jurisprudence, which we have done recently as well, when we look at the difference between just simply describing what the law is, describing how the law works, and then also going into and examining the actual normative approaches, i.e. what ought the law be? Why are some parts of the criminal law subject to socio-legal critiques, etc., etc., etc. So all of this is going to be really important in this new series. This does not mean that we're going to just be avoiding the talking about and the discussion of substantive crimes as well. Of course, we're going to be talking about murder, manslaughter, sexual offences. We're going to be talking about principles of essential elements of crimes. So, for example, the actus reus, the mens rea of an offence, causation. But we're also going to be doing so through the lens of more critical approaches as well, as and when we need to actually approach it from a critical understanding. So as an early introduction, let's think about this through the perspective of taking ourselves back all the way away from the substantive crimes themselves, so looking at what murder is, for example. Let's just think, well, what is crime? What is a crime? What does it mean for something to be a crime? Now, you might think that this is a relatively easy an easy question to answer, should I say, especially because for the most part, you would argue that the criminal law is most colloquially well understood and well known. People know what a crime is, for example. Less people will know what it means to say that something is put on trust or something is a tort. Those are areas of law which are, while still very accessible to the general public, they are not as accessible in terms of the sort of deep embedded colloquial understanding as that of crime. Well, despite this fact, and despite the fact that we can all name a crime and we can all define what we think a crime is, the definition of a crime is one which has attracted a lot of debate and deliberation from various different philosophers throughout the centuries, legal theorists throughout the centuries. According to the Oxford English Dictionary, for example, they suggest that a crime, or that the idea of crime, is potentially some kind of act or omission. I've added that bit in there. They've said that essentially a non-lawful activity, but I've also made it clear that you can have an omission as part of a crime as well. But they say that it is an act or an omission which is considered to be unlawful. And in addition to this, they suggest that maybe one of the caveats for criminal liability and for a crime is this idea of the unlawful nature of the act or the omission being sufficient to warrant the intervention from the state, or potentially that not necessarily it meets a particular threshold for the intervention of the state, but that the state intervenes and that is what makes something a crime. All of these are generally acceptable theories and generally acceptable definitions. They're not necessarily universally accepted. Some may argue that it is tautological to talk about crime as being, quote, something unlawful, because then you might say, well, what does it mean for something to be unlawful? And you could almost define something being unlawful as something as being a crime. That would sort of blur the lines between the idea of the civil and the criminal in terms of the two jurisdictional elements of the English legal system. But some of these definitions are debated, is the point of this slide. And essentially the idea of what a crime is not universally understood and is not universally accepted. And so we can have general conditions, shall we say, or general features of what a crime may be. So some kind of unlawful act, the intervention of the state prosecuting that individual rather than the individual who is harmed or who is wronged in some way being the person who does the prosecuting, which is of course what happens when we look at civil liability for certain actions. And in this case, you can actually look at quite useful parallels between civil and criminal jurisdictions, because you can look at, for example, certain torts, which can be considered to be both civil and criminal in terms of the actual act itself. So intentional torts such as that of assault and battery will find you will be able to, at least, or there will or could potentially be liability in both civil and criminal jurisdictions. So you might look at that and go, well, the acts are essentially the same. The acts are the same in both of these circumstances. The facts themselves. What is it that makes this one a crime and this one a tort, something that is civilly liable and one that is criminally liable? Most would answer that in the case of the criminal liability for assault or battery, for example, you would say that it is the state that intervenes, rather than in the civil elements of assault and battery within tort, it is the person who is making the claim, who is actually wronged, who is harmed in some way, that can therefore make the claim and sue the defendant. Now, in terms of statute law, there are also definitions of what constitutes a crime, and I've just picked an example here, Section 243, subsection 2 of the Trade Union and Labour Relations Consolidation Act from 1992, where it says that a crime for this purpose means an offence punishable on indictment, or an offence punishable on summary conviction, and for the commission of which the offender is liable under the statute, making the offence punishable to be imprisoned either absolutely or at the discretion of the court as an alternative for some other punishment. Now, this gives a definition of a crime for the purposes of the specific legislation. So this is in relation to trade union and labour law, which is of course something that we are not covering in this series of lessons, as you can imagine. But it also gives us some further delineations relating to what a crime could potentially be, or at least a different way in which we can classify different kinds of crime. You have here, for example, as stated in this particular provision, the idea of an offence being punishable either on indictment or punishable by way of summary conviction. What is the distinction between a summary conviction and an indictment? What is therefore the distinction between the jurisdictions of the various elements of the English judiciary, so for example that of the Crown Court versus that of magistrates, the lay magistrates? Well, ultimately, this is things that we're going to be talking about in future lessons time. This is also content and subject matter that we're going to be focusing on when we look in more detail in a series on the English legal system, just as a general introductory legal series as well. So these are things that are going to be covered in far more detail, but I've just put this here as a general indication of how crime is defined in other contexts and in other circumstances, and also how crime can be delineated by way of maybe an offence being punishable on indictment or through a summary conviction. So essentially, what I want to take away from this is this theoretical approach towards criminalization and criminal offences, the idea of really the debate around what makes something a criminal offence, and then what are potentially the necessary or sufficient factors in the process of criminalization. For those who have never studied or had any kind of interaction with philosophy, the terms necessary and sufficient are philosophical terms. So in terms of what it means for something to be a thing, there are often a lot of conditions attached to the idea of that thing being a thing. So, for example, the idea of a crime being a crime, there are often conditions attached to that. Something is a necessary condition if it is required for that to exist. So if I say that, for example, and this is not necessarily true, but let's just, for a hypothetical example, I say that there has to be some kind of harm in order for something to be a crime, then that would suggest that it is a necessary condition, such that if that condition is not there, then the thing that we are identifying is not a crime. Now, a sufficient condition is one that essentially brings the thing into existence in and of itself. So, for example, I could say, well, what is a crime? Well, a sufficient condition for a crime is that it is either expressed through the common law or through statute or potentially through international treaties, for example, or at least in the context of England and Wales, it would either be through the common law or through statute. Those are actually sufficient conditions for a crime. If Parliament passes a law tomorrow suggesting that, for example, waving to your neighbour is a crime, they have the right to do so through the idea of parliamentary sovereignty, and that would be a sufficient condition for that thing to become a crime. But again, these are very heavily debated. This is going beyond not just the specific doctrinal analysis of criminalization, but also the philosophical and socio-legal approaches to criminalization as well. Does, for example, an act or omission require the the perpetrator, to commit some kind of harm? This is what is known as the harm principle. The idea that what makes something a crime is it's an act that causes some kind of harm. Now, there are various pros and cons to this particular approach, and there are various different alternatives and variations on this approach, but this is one of the major approaches within the sort of general philosophy of criminal law. Does an act or omission require the breach of public morals or just general ethics? This is again another major approach known as legal moralism. And again, you can come to a conclusion that actually for something to be a crime, it has to be immoral. Now you're getting into the weeds as to what constitutes something that is immoral there, and people will also come back at you, should I say, with a number of different examples of acts which are probably considered to be immoral but are not considered to be a crime. So, for example, cheating on your significant other would be considered immoral in most circumstances, if not all circumstances, but it is not a crime to do so. So, again, heavily debated in a number of different ways. Does knowledge of wrongdoing matter? Does the perpetrator have to know that what they're doing is wrong in order for that to be considered a crime? This brings into the idea of a guilty mind, the idea of the mens rea of an offence, the intent to commit an offence, versus what is known as strict liability, where intent doesn't necessarily matter. The fact that you did it does not deter. Or at least the fact that you did it and you may have done it not knowing that you have done it, or not knowing that what you had done was a crime, that does not necessarily absolve you from liability. And so, again, does it matter in all contexts? Some crimes are not strict liability, some crimes are. We'll get to which crimes are which as we go on in future lessons. Do all crimes require a victim? If so, what relationship does the state have with that victim in question? And this brings us to another point, which is essentially one of the purposes of the criminal law. And this relates to this approach known as paternalism and a paternalistic outlook towards the state. In a great many different cases within criminal law, it seems to be the case that the state exists to protect those who may be victims of crimes, or essentially to support those who may be victims of crimes, or who have been a victim of a crime in the past. And I guess this all also ties into an idea of a theory of punishment being one to essentially deter people from committing crimes in the first place. You're doing so potentially to protect those who could be the victims of said crimes, and this gives the state a certain idea of paternalism. It gives the state a certain role as being paternalistic. The idea of paternalism is this idea that you limit the autonomy of certain individuals in society's actions, or all of society's actions, and that the justification for doing so is to protect those who are in society who need it most. It is quite paternalistic. And so this is really a question of the relationship between the criminal law and the state, and the relation that those two have with the people and society more generally. Does the state utilize the criminal law and justify the existence of the criminal law on the basis of protecting those in society who need it most? If so, then we are talking about it from a particularly paternalistic standpoint. It's a generally accepted view that when we see the state intervening and instituting criminal offences and prosecuting criminal offences, that they are doing so with the understanding that, and this is a sort of generally understood belief that it is a good thing for society for the state to be able to prosecute those who commit criminal offences, and therefore also have the power to limit the actions of anyone who tries to commit a criminal offence, whether that be through a post hoc prosecution of people who commit that, or even if it maybe deters people from potentially committing it in the future by labeling it as a criminal offence. So this first lesson has been very theoretical, and I'm afraid it's going to be even more theoretical as we go on in the next few lessons' time, but I will just want to outline the scope of this series in more detail here. We're going to be dividing this series into a number of specific sections. Within each of those sections are going to be specific lessons, and these sections are going to be highlighted at the start of each lesson, just above the title, as is the case in every single presentation that we do. And the first section is going to be, as you may think already, theories and principles of the criminal law. We're going to talk about some more of the theoretical elements, not going into too much detail as to the philosophy of criminal law, because that is a beast in and of itself, but also talking about the concept of punishment, the idea of evidence within criminal proceedings, the idea of defense, prosecution, the common law system, and just general subsidiary issues relating to criminalization. We will then talk about the question as to what makes a crime. This is going to be a little bit more doctrinal and getting into actually the law itself, the black letter law itself. This section is going to examine the various elements of criminal liability, looking at what it means for something to be a crime, what are required, what are the essential elements for a crime to exist. This involves looking at the concept of the actus reus, the mens rea, the idea of criminal offence or lack thereof, in terms of giving rise to criminal liability, the idea of an omission being a crime as opposed to just an act, the causation of the acts and the mens rea towards the actual the actual bringing about of the events that takes place, the concept of strict liability, the concept of secondary participation in criminal liability, so parties to a crime, and then a subsidiary issue in relation to parties to a crime, which is this idea of inchoate liability as well. And then in the third section, we're going to actually get on to using all of the things that we have talked about in these first two sections to apply those to specific criminal offences. Talking first about murder, then manslaughter, sexual offences, non-fatal offences, such as assault and battery, for example, and then property offences. We'll spend a lot of time on property offences because they can be divided into a variety of different types. So we're going to be talking about, for example, theft, fraud, making off without payment, burglary, etc., etc., etc. And then finally, we're going to talk about defense to criminal liability. These can be broadly delineated into three major categories. We have defenses relating to capacity, so things such as the defense of insanity, intoxication, things like automatism, for example. We also have compulsion related defenses, so things relating to things such as duress, the division between duress by threats and duress by circumstance, and then also the idea of mistake within criminal law. Welcome everyone back to Criminal Law. This is the penultimate lesson looking at some of the introductory theories and principles of the criminal law within the jurisdiction of England and Wales. This lesson is going to talk about the types of crimes that exist. Now, this is not going to be necessarily talking about the types of crimes by way of the distinction between, for example, result crimes and conduct crimes, for example. This is something that we'll look at when we examine principles relating to omissions and causation. This lesson is going to focus on the type of crimes and the ways in which we have jurisdictional systems within the criminal justice system, which delineates the types of crimes which may exist. And in this regard, we're going to talk about the main delineation between summary offences and what are known as indictable offences. And then we will talk about the various differences in terms of their jurisdictional makeup, as well as the quite interesting delineation, or at least the types of crimes that exist that could be either summary or indictable, which are sometimes known as halfway offences, or will be considered to be in the middle between the summary and the indictable type of offence. Now, this is going to be an introductory-esque lesson to this idea, because of course this is a lesson that would really be fit more a course on the criminal justice system rather than specifically the criminal law. And we will get to looking at the criminal justice system in more detail in future lessons' time. So we will get to this in more detail in those lessons. But for now, this is just an introductory overview of the delineation that is often made between summary offences and indictable offences. So essentially, when we look at summary offences, these are the kinds of offences which in some common law jurisdictions are described as petty offences, okay? And this might be a way of being able to make that clear delineation between what a summary versus an indictable offence is. If you were to suggest that a summary offence is sometimes described as a petty offence, then you can get a clearer idea of what we're talking about when we talk about summary offences. We're talking about much smaller criminal offences, much smaller crimes, which often have smaller penalties attached to them. They are called summary offences because the proceedings which are operated when somebody is accused of a summary offence is done summarily, which means that it is lacking a jury, it is lacking a jury trial and a formal indictment. According to Blackstone, the commentaries in the law on the laws of England, we see that by a summary proceeding, I mean principally such as is directed by several Acts of Parliament for the conviction of offenders and the inflicting of certain penalties created by those Acts of Parliament. In these, there is no intervention of a jury, but the party accused is acquitted or condemned by the suffrage of such person only as the statute has appointed a judge. So the most important point that we have to note here from Blackstone's commentaries here is the idea that there is no intervention of a jury. There is no jury trial when we talk about the offences which are tried summarily, rather than when we look at indictable offences, they are a lot more serious. They require the issuance of an indictment. An indictment is simply a formal accusation that a person has committed a crime, a formal accusation which is presented by the state to the defendant. Now, when we talk about the system of England and Wales, the indictment, being something that is formally issued by the state, is actually specifically issued by a public prosecutor in England and Wales. This is often either the Crown Prosecution Service, acting under the remit of the DPP, or the DPP themselves, the Director of Public Prosecutions. They sort of operate together as being the process by which an indictment is issued. So, for the most part, this is done by the Crown Prosecution Service, the CPS. And when we look at an indictable offence, we often have if the defendant pleads not guilty, we will have a trial by jury. They'll have a jury trial. Now, in terms of jurisdictions, in terms of the different court structures that exist between the summary versus the indictable offence, you will note that the summary offence will take place summarily through the magistrate's system. So in a magistrate's system, there will be no jury. There'll either be an appointed judge, or there'll be a panel of 3 what we call lay magistrates. On the other hand, as per Section 75(1) of the Senior Courts Act, an indictment must be tried either by a High Court judge, by a circuit judge, or a recorder. And this means that we have a requirement that an indictable offence takes place in Crown Court. So this isn't necessarily a sort of general convention. This is a statutory requirement. If you have a summary offence, you will be tried by a magistrate, either through an appointed judge or a panel of lay magistrates. if you have been issued an indictment, if an indictment has been issued by the CPS or the DPP, then this means that according to Section 75, subsection 1 of the 1981 Senior Courts Act, the indictment must be tried, assuming you plead not guilty, by a High Court judge, a circuit judge, or a recorder. What about the sort of in-the-middle offences, or either-way offences, or sometimes described as hybrid offences? These are the kinds of offences which may have dual jurisdictional competence. It means that they may be either tried summarily or tried by way of an indictment. So we can see either a summary offence or an indictment offence. And it is often the case that when we talk about the types of offences which exist, it is the smaller offences, the less serious offences, which are tried summarily, and then the more serious offences, which are often tried by way of an indictment. So, small and minor offences often are tried summarily. So, certain driving offences, certain assaults or battery, the sort of lower end of the non-fatal offences. And the reason for this is, of course, the fact that there is a certain severity attached to these offences. There is a certain amount of expenditure which is had when we talk about an indictable offence. A Crown Court, we are talking about a trial by jury. It's often quite a much longer process, a much more significant process, which has attached to it a much heavier sentencing, a much heavier punishment, which may be attached if that individual is found guilty. And so as a result of this, the smaller driving offences probably ought not to be tried by way of an indictment and through a trial by jury, which then has attached to it a significant penalty by way of punishment. And so as a result of this, we have summary offences such as these having quite limited sentencing powers. So, for example, magistrates have a limited 6-month sentence for each offence, and they also are limited to up to £5,000 in terms of the issuance of fines that they can instigate. More serious offences, on the other hand, offences like murder, sexual offences, some of the higher non-fatal offences, such as GBH, for example, may take place by way of an indictment. An indictment will act in a similar way to that of what is known as a summons within the purview and the jurisdiction of a magistrate. But the involvement defendant will be tried by the Crown Court, will be tried in Crown Court. This is obviously as per the Senior Courts Act of 1981, Section 75, subsection 1. Welcome back, everybody, to Criminal Law. In this final lesson looking at theories and principles of the criminal law, what I'm going to be doing is talking about the concept of the burden of proof. Now, again, this is part of more the substantial procedural elements of criminal law, so talking a lot about criminal evidence and the way in which the burden of proof and the standard of proof is interpreted in that regard. So this is going to be something of an introductory overview of how the burden of proof operates within the criminal law system, specifically within the adversarial system of the common law jury trial. And we're going to be focusing on one specific case for the most part. It is a landmark case that involves a murder charge, which we'll get to. And of course, this is going to be something that we're going to look at again as we get on to looking at the substantive law behind murder in more detail. So this is one of the basic principles pertaining to the criminal justice system within the common law jurisdiction of England and Wales. And this is generally the view that we have what is known as a presumption of innocence. It is the procedural requirement that an individual is essentially who is accused of a crime, an individual who is a defendant accused of a crime, is presumed to be innocent. And it is for the trier of the case to make the argument of the defendant's guilt. Now, this relates to the burden of proof. Who is burdened with the obligation to prove the facts of a particular issue, to prove guilt. This does not pertain necessarily to the standard of proof. The standard of proof is not who has to make who has to do the proving, but it is to what level do they have to make that proof possible. So in a civil case, for example, it would be on the balance of probabilities, whether or not, given a case, would it on balance of probability be the case that the individual who is accused of a particular thing did that particular thing, or could be found to be guilty of that particular thing. The burden of proof and the standard of proof in criminal jurisdictions is a little bit higher, and we'll get to that in future lessons' time. But when we look at this, the burden of proof essentially enshrines this principle within the criminal law jurisdiction in England and Wales of the presumption of innocence. The basic presumption which has to be adhered in the majority of criminal trials, which we'll get to some exceptions at the end of this lesson, is this idea that the defendant is presumed to be innocent. And it is not up to the defendant to prove that they are innocent. It is not up to the defendant to prove that they are not guilty. It is instead the positive obligation of the prosecution to make the case that the defendant is guilty. The burden that is placed on the trier of the case, the people who are in charge of making the prosecution, and to essentially to prove the guilt of an individual rather than the individual proving their innocence or proving their non-guilt in a particular way. Now, one of the most famous cases in English law actually exemplifies this particular fact, and this is the case of Walmington and the Director of Public Prosecutions from 1935. We're going to explain the facts of this case. We're going to explain the major defense that was levied in this case, and then we're going to talk a little bit about the argument that the presumption of innocence and the burden of proof was enshrined as part of this case. This isn't where the burden of proof came from. This isn't like the precedent that you would cite, but it is just an exemplifying example of where the Director of Public Prosecutions tried to make a case of reversing the onus onto the defendant, and the courts made it very clear that that is not what the purpose of the common law criminal jurisdiction actually is. So in terms of facts, we have the defendant here, who is a person by the name of Reginald Warmington, who was a farm labourer and who had married an individual by the name of Violet in 1934. They had a child a year later, so they were married with a child. And then shortly after having a child, the two would fall out, and Violet would then resultingly leave the family home and go and live with her mother for some time. Now, this is really where we start to see the facts of the particular crime take place. In response to this, in response to the fact that Violet left the family home, in December 1934, Reginald would take a double-barreled shotgun and travel to his mother-in-law's house and shoot and kill Violet. This is what happens. Now, he would, of course, be subsequently arrested and charged with the murder of Violet. In terms of Mr. Warmington's defence, he argued that he was not guilty of murder owing to the fact that he didn't have the sufficient, what we describe as mens rea, for the murder, since he had not intended to kill Violet. We'll get to this in the next lesson when we actually look at the substantive elements of criminal liability. But mens rea essentially just refers to the guilty mind, such that when we are talking about murder, in this instance, it is not enough to have just committed the act, which is the killing of the individual, killing of Violet. You have to have done so with the guilty mind, with the intent to kill that individual, in order to sufficiently have not only the act itself, the actus reus, but also the mens rea, the guilty mind. And so as a result of this, given the fact that he argues that he was not intending to kill Violet, it meant that his defense was, well, I can't have been found guilty of murder because I didn't have the sufficient intent to kill, therefore not the sufficient mens rea. We will get to, again, the sort of the criminal elements of murder when we get onto that particular offence. So instead, what his plan was to try and get her back by threatening to kill himself. So his argument was, I went to the house with this shotgun, I was going to point this gun at myself, and I was going to threaten to kill myself unless Violet came back and resumed, presumably, our relationship. And so, in the course of events taking place, the gun had accidentally shot, and he had accidentally shot his wife Violet. Now, this case became incredibly important because what it did was confirm the presumption of innocence within criminal law, and this culminated in a very famous speech by Viscount Sankey through this idea of the golden thread. Now, what he says is that throughout the web of English criminal law, one golden thread is always to be seen. That is the duty of the prosecution to prove the prisoner's guilt, subject to the defense of insanity and subject to any statutory exception. This all came from the view in his second trial by Judge Swift, and Judge Swift essentially the case was so strong against Reginald on the facts that they reversed the onus. They said that because the case for murder was so strong, it was up to you to show that the shooting was accidental. Because we have so much evidence, and because we have such a strong case for the fact that you went and murdered this particular individual, you need to prove that it wasn't murder, that it was actually this story that you are trying to convey to the jury, or at least to the judge. And so as a result of this, what the trial judge does is reverse the onus, place the burden of proof onto the defendant, Reginald Wilmington, in the ability to essentially show that the shooting was accidental. It was now up to him to show that the shooting was accidental, which is essentially him being forced to show that he is not guilty, and so he now has the burden of non-guilt rather than the burden of proof for guilt, which is on the prosecution. There was a presumption of guilt, and the burden of proof was on the defendant to show otherwise. They was presumed, because the case was so strong, it was presumed that it was murder automatically, and it was up to Reginald to actually make the argument that it wasn't. This is, of course, reverse onus. Now, in terms of reverse onus offences, there are actually some that exist. In some circumstances, there are offences where there actually is this onus to show non-guilt, and this is placed on the defendant. Quite controversial in a lot of examples, potentially quite discriminatory in a lot of examples, and it happens a lot, for example, in the case of terrorism legislation. So if we look, for example, at the 2000 Terrorist Act, specifically Section 57, subsection 1, it says that a person commits an offence if he possesses an article in circumstances which give rise to reasonable suspicion that his possession is for the purpose connected with the commission, preparation, or instigation of an act of terrorism. So essentially, this is in terms of possessing some kind of article which is connected to terrorism, so maybe some kind of terrorist handbook, for example, and they automatically give rise to this suspicion, and it is up to the defendant in this particular example to prove otherwise, to prove the other reason why that they have this particular item within their possession. And so as a result of that, this particular provision within the Terrorism Act is actually something of a reverse onus offence, in the sense that it is now up to the defendant to prove otherwise, and it is just assumed in those circumstances that a person has a reasonable that they possess the particular item for the purpose connected with the commission, preparation, or instigation of an act of terrorism.